Good afternoon. I think some people are still logging on, but we will get started. I'm Adam Gersh, and I'm a shareholder in Flaster Greenberg, and I help businesses with labor and employment matters. It's my pleasure to welcome you to our COVID-19 webinar for businesses. Across a wide array of sectors, businesses are facing some of the biggest challenges ever. We recognize that there is no precedent for this and that the situation, laws, and appropriate responses are fluid and require rapid responses to stay on top of it. I'm here today with my fellow colleagues, Doug Stanger, a shareholder in our bankruptcy reorganization and financial restructuring practice group, and Eric Loy, an attorney in our tax practice group. For the next hour, we're going to talk to you about frequently asked questions and guidance for business amid this COVID-19 pandemic that's affecting virtually every business around the world. All of our panelists today have been analyzing the impacts that existing, new, and proposed laws will have on employers and individuals in this COVID-19 world, and we're looking forward to sharing our thoughts with you. There are a number of you interested in this topic, so we imagine there will be a lot of questions being asked throughout the presentation. We've designated time after our presentation to answer your questions. To ask a question, simply click on the chat feature at the bottom of your screen to send a question to our panelists. We will do our best to answer all of your questions within the allotted 1 hour time of the webinar. Now, since we are lawyers, we need to give our disclaimers, and you should see a disclaimer slide any moment now. We need to include this in the slide deck so that everybody understands that this is not legal advice. Secondly, I want to let you know that the webinar has been approved for 1 SHRM, HRCI, and CPE credit. To obtain a certificate of attendance for any credit offered today, please just send an email to marketing@flastergreenberg.com. Unfortunately, we do not have CLE available for this presentation for any attorneys on the line. I will ask anybody who is on the line to please put your name and email in the chat window and send it through so that we can stay in touch with you and track who's attending. Also, due to the complexity of the topic, we're currently recording this webinar so that our attendees are easily able to revert back to any PowerPoint slide that's not covered in its entirety and to hear this again. Our marketing department will send you a link to the webinar as soon as it's live on our firm's COVID-19 resource page. What to do with my workforce? Employers are asking this question every day and every minute because things are changing. And as we say on the slide, it's really like trying to do a jigsaw puzzle where the number of pieces, the shapes of the pieces, and the finished picture are changing all while you are working. It's nearly impossible. And we do understand that employers do not know what to do and that their plans are changing constantly. We're going to talk today about some of the latest developments, but we expect more and we will be doing our best to keep you up to date. We do expect to host additional webinars, and in fact, I invite you in the chat window to advise of any topics that are of particular interest to you. Obviously, today is going to be focusing on employment aspects, certain tax aspects, and certain bankruptcy and reorganization aspects of the issues that are facing businesses right now because of the COVID-19 crisis, but there are other practice areas that will also be involved. So we certainly welcome that so we can bring you material that's relevant. We would also be remiss if we did not reference the stimulus bill. It was announced on Tuesday night and passed by the Senate. It may provide important incentives and relief for employers who maintain their employees. The full bill was just released last night. However, we're in the process of going through it, and right now it looks like the House is likely to vote in on it on Friday. So we do expect some movement here, but for now we're going to focus on the laws that have passed. Moving on. Part of what makes this so complex for employers is just the sheer number of laws that overlap and affect every decision. I'm going to go through briefly some of the most important ones. The first is going to be our Families First Coronavirus Response Act. That's the new law that was just passed last week. We'll get into that and into the detail about the leave that's available and some of the tax credits that are available. There are other aspects to the law, but that's what we're going to be focusing on today. The COVID-19 crisis has also implicated the Family Medical Leave Act. And I say that in two different ways. The traditional Family Medical Leave Act, which many employers are familiar with, applies to employers with 50 or more employees, but also special Family Medical Leave Act provisions under the Families First Coronavirus Response Act. It also implicates the ADA, which is the Americans with Disability Act, also state anti-disability discrimination laws that have similar protections for employees. That comes up both for employees who are actually injured as a result of the COVID-19 outbreak, but also employees who have other symptoms and other disabilities triggered by this, for instance, anxiety. Next, it also implicates the National Labor Relations Act. And I want to stop here for one moment because I know employers often think that the National Labor Relations Act does not apply to them if they don't have a unionized workforce. That's not the case. The National Labor Relations Act does protect certain rights that would be protected whether you have a union or not. We'll get into some of the important ones in the Q&A. Title VII, which is our anti-discrimination law federally. I see that. And then the WARN Act, which is, we have our federal WARN Act and our mini WARN. Our mini WARN applies to many state laws, but really it relates to what notice you have to give in the event that you are in fact having a mass layoff or closing down. It's important to note that New Jersey and New Jersey's own WARN Act is going to evolve in July and require additional notice. But for now, we need to think about the implications of the WARN Act if you're closing for greater than 6 months. Also, it applies to employers who employ more than 100 people. So if you have a layoff of even just 50 employees, but they represent 1/3 of your workforce, the WARN Act would apply and require certain notices. And if notices aren't given and there's not a viable exemption from giving those notices due to, for instance, a faltering company exception or in certain instances, an unforeseen circumstances exception, there could be liability under the WARN Act. So it obviously relates specifically to everybody's own business, but it's something to keep in mind. And the Fair Labor Standards Act, we're going to get into how that applies a little bit more in the Q&A. Moving on. What benefits apply? And again, we have this array of laws, and then we also have an array of potential benefits that overlap. We have the FFCRA leave, we have FMLA leave, potentially for sick people. We have reasonable accommodations if this is either creating a disability or triggering a disability. We have unemployment benefits, which unfortunately has become a focus now that so many workforces are laid off. We do have sick leave, both under New Jersey's earned sick leave law and any sick leave under each company's policy. We have paid time off under company policies, and also COBRA benefits apply in many instances. So those are sort of the overlapping issues we're dealing with. I think rather than go through a lecture on each one of these laws and benefits, let's apply this by going through some of the Q&A, and I think it'll help crystallize everybody's understanding. So we'll move on to the first question here. Can I have the next slide, please? What's the difference between a layoff and a furlough? This is a question that we received from some of our attendees, and I've certainly been working with employers over the last 10 days to discuss. First of all, furlough sounds a lot friendlier. So I think people are using the term furlough to reflect the idea that a layoff is temporary. A furlough can actually also be used to apply to a reduction in hours or, you know, certain people taking unpaid weeks and rotating. I think the most important thing to understand is that typically the word furlough or a layoff is, in this instance, both if you're not paying employees for hours worked and they're not receiving their regular pay, could make somebody eligible for unemployment, assuming that all other eligibility requirements are met. Really, so one of the questions: are you going to keep somebody on payroll, and are you going to continue their benefits, and will you be reinstating them with seniority? You can do any of those things. Whether it's a layoff or a furlough. I mean, you're not going to be paying somebody on payroll, obviously, if they're on a layoff. But you do have some rights, and we'll get into it more, to continue benefits and certainly reinstatement with seniority. There are also policies and laws that affect whether somebody gets reinstated with seniority and the continuation of benefits. Depending on if you have a union, there may be a period of time within which somebody's laid off, they do maintain their seniority. Important for our New Jersey employers out there is that if people do have accrued New Jersey sick leave and they have not used it in connection with, you know, before being laid off, if they're rehired within 6 months, that sick leave would need to be reinstated. So that's true whether you call it a furlough or a layoff. Really, I think the idea people are trying to convey to employees is that when we get back to business, we want you back. And in the interim, if you're not working, we want you to be able to collect unemployment. So I hope that helps distinguish between the layoff furlough question, which we're getting at. I think legally, you'll find that the more important thing is what you're doing than what you call it. Let's move on. What are the implications of reducing full-time employees to part-time? So this has been a continual question, because one of the ways employers have tried to spread the pain of having fewer hours and less work to do has been to treat everybody as part-time rather than having a layoff of some portion of the workforce. Certainly there are certain workforces that this works for operationally and others that don't. A couple important things though: if you're going to do this, there are implications. First and foremost are the federal and state wage and hour laws. And the reason I bring this up, and the reason that this is often overlooked, is because the exemptions for certain white collar exemptions, administrative, executive exemptions, are two-part tests. So that means that an employee must meet a duties test and a salary test. So even if the duties aren't the same, if the salary dips below $684 a week and you're treating this person as exempt, they're no longer exempt and you need to treat them as hourly. Let me be clear about that, because practically the point of treating somebody as hourly is that they'd be or as non-exempt is that they'd be eligible for overtime. Practically, if you're reducing people from full-time to part-time, you're not going to likely have them working overtime. Obviously, they still have to make minimum wage. But the overtime issue doesn't have a huge practical effect, but it does mean you need to be tracking their hours and recording people's hours to make sure you don't have a violation here, even though you're actually not having overtime work. The second issue that I want to highlight is the duties test. If you're relying on certain duties tests, for instance, if you're relying on the idea that somebody is supervising more than one employee to meet a white collar exemption and you have a layoff, you may not have that supervisory criteria anymore. They may only be supervising one person and therefore may not qualify to be treated as exempt. So you do need to look at the ways in which potentially reducing people's hours will impact your wage and hour law compliance. One other point I think we need to point out here is that this can also affect eligibility under health plans. This has been a constant issue here. If we bring people to part-time, many health plans are designed to cover employees who are full-time or greater. Depending on your contract may define that differently. Some are 25 hours or more, some are 21 hours or more, some are 30, 32, and I don't know that any are above 32. I have seen those eligibility requirements relaxed by certain healthcare insurers for certain employers. And if you are looking to reduce hours and maintain people's health insurance, I highly recommend that you reach out individually to your insurer or your broker to find out if that's available. What you do not want to do is have somebody in a position where they are think they have health care and turns out they're not eligible. So let's move on to the next question because I want to keep this going. Can I require an employee who is scared of infection to come to work or face discipline? So this implicates a number of laws. If the employee's fear is triggering an underlying condition, there may be protections under the Americans with Disabilities Act or the New Jersey Law Against Discrimination or the Pennsylvania Human Relations Act or any other state anti-discrimination protections. It also can implicate OSHA if there's a direct threat. If more than one employee is protesting coming to work, it can be deemed a concerted action under the National Labor Relations Act. That's where one of the areas the National Labor Relations Act applies whether you have a unionized workforce or not. Also in New Jersey, we have a Conscientious Employee Protection Act, which protects employees from retaliation if they refuse to engage in conduct that they reasonably believe to be a danger to health. So all of those things are potential areas of liability for employers, which is why I think employers need to be very thoughtful and careful as to whether they're going to discipline an employee and understand and appreciate the risks of liability if they do so. Moving on. What do I do if I am conducting a layoff and can I maintain benefits for those who are collecting unemployment? So the answer is you're allowed to lay off employees when necessary and when appropriate. Obviously, if you have a union contract, you have to follow that. If you are paying any portion of your employee contribution or the employer contribution while somebody is out on unemployment, which you can do, you just need to arrange for how that's going to work. If you're paying the employee portion, are you going to double deduct when they come back? Are you going to treat it as an advance? There are a couple of different things to do, but it can be done. You just need to consult with counsel. Moving on to the next question. Can I use a force majeure clause to change the terms of an employment contract? So we are getting this. I think that many contracts don't actually have force majeure clauses. If they do, you need to read the clause and see what it says and see whether this COVID-19 episode is actually a qualifying condition. Also, under common law, there is an implication of of a force majeure concept, at least when performance of a contract becomes impossible. So this may often lead to renegotiation of an employment contract. You really need to look at the terms of the employment contract and whether there's an opportunity here to determine whether there's a impossibility of performance due to, for instance, a forced closure of a non-essential business. Moving on to the next question. Which employees are entitled to leave under the Families First Coronavirus Response Act? We're going to be calling that the FFCRA going forward. And what leave do they earn? So this is the big question and really the new thing facing many employers. We have three categories of people who are entitled to leave, and you'll see on the next slide our first category. Our first category is somebody who's symptomatic and getting diagnosed, subject to a quarantine or isolation order. We're going to get into that in a little bit, and ordered by a healthcare provider to quarantine, for instance, because they've been exposed to somebody. That person's now entitled to 80 hours of leave, up to 80 hours, 2 weeks, so whatever their regular schedule is. They would get up to 80 hours of leave. It's paid at their full rate, capped at $511 a day. And there is a tax credit for that payment. So this is new, and this is leave in addition to any other leave they may have under state law or your own policies. And you cannot force somebody to use their accrued PTO or sick time or anything else in advance of using this leave. I want to move on and explain the next category. Our category 2 people are people who also get sick leave up to 2 weeks. These are employees who are caring for a family member who is in the condition of the first part of the first category, right? Somebody who's symptomatic and getting diagnosed, somebody who's subject to a quarantine or isolation order, or somebody who's been ordered by a healthcare provider to quarantine. But rather than full rate, these people who are caring for family members are paid for 2 weeks at 2/3 of their pay, up to $200 a day. So that's capped at $200 a day. Now moving on to our third category, if I may. This is a little different. So now we have, this is leave up to 2 weeks first for an employee with a child whose school place of care and or care provider is unavailable due to COVID-19 precautions. These employees have an additional 10 weeks of Emergency Family Medical Leave Act, again paid at 2/3 up to $200 a day. Now, the mechanics of this, if you try to read the law, are very confusing because essentially you have 12 full weeks of FMLA leave under this provision. The first 2 weeks of FMLA leave are unpaid as FMLA leave, but they are paid as sick leave. So you have emergency sick leave covers your first 2 weeks, and paid FMLA covers the back 10. So you get a total of 10 of 12 weeks paid between the sick leave and the FMLA. It's different because traditionally FMLA is unpaid. And so this is unique in that it is paid. And also it's unique in that it applies to employers whether you have one employee or 499 employees. If you have 500, you're exempt, but 1 to 499, it's not the old standard of FMLA that you have to have 50 or more employees. Also, an employee does not have to have worked for a year to be eligible, which is traditionally the 12-month requirement for FMLA. They only have to have been employed for 30 days. So this is really unique. And it's an important kind of leave to understand. Let's move on to some other FFCRA questions now that you understand the leave. What businesses are exempt from the leave? Well, I already mentioned briefly that if you have more than 500 employees, you are exempt from the requirements of leave under FFCRA. There's also an exemption under the law for certain healthcare providers and emergency responders who opt out. Now, we don't really have guidance much on this yet. The Secretary of the Department of Labor is permitted to delineate which healthcare providers and emergency responders can opt out of that. We would expect that to likely be healthcare providers who are on the front lines and can't afford to have employees on leave, especially job protected leave. But we don't know that yet. So right now it does allow certain healthcare providers and emergency responders to opt out. Let's move on to the next question. Do I owe leave under the FFCRA to employees who are on a layoff? So this is a very common question. We just learned that you may have all of these leave obligations to your employees, especially in New Jersey, where almost every school and daycare are closed. But the answer is if you don't have a workforce, you do not owe leave under the FFCRA. Leave is for employees who are asked to work and cannot. It's to protect those employees. But if somebody is on layoff because your business is closed, that would not be a qualifying reason for the FFCRA leave. Moving on to the next question. Do the stay-at-home orders from Pennsylvania, New Jersey, and New York's governors amount to quarantine or isolation orders under the Relief Act? So if you remember, Category 1 and 2 under the FFCRA triggers certain leave if either an employee is on a quarantine or isolation order or an employee is taking care of somebody who's on a quarantine or isolation order. There's been a lot of debate back and forth, but the dominant belief here is that the current stay-at-home orders are not what quarantine or isolation orders as defined in the Act. Well, the Act doesn't define them, but at least as referenced in the Act. Otherwise, everybody in the tri-state area would be entitled to this leave, or at least many of them would be. And we are not ordered to quarantine or isolate. We're ordered to stay home Important point too about the leave that I just want to make sure everybody gets is that the leave is available to employees who cannot remote work. So if you have an employee who can remote work and is willing to, then they would not be entitled to the leave. Importantly though, for instance, for someone who's caring for another or is sick or is caring for a child, they may have the capability to remote work based on your technology platform, but it doesn't necessarily mean that they can do it if they're caring for somebody else or if they're ill. Moving on. At this point, I'm going to turn the presentation over to my colleague, Eric Loy. Again, as I mentioned at the top, Eric is one of our colleagues in our tax practice group, and Eric's going to explain how the tax credit, the payroll tax credit of the Family First Coronavirus Response Act works. We'll also be looking for some questions you have and come back and answer those after Eric and Doug have an opportunity to present their information. Thank you very much. I'm sorry, I think Eric's on mute. We're going to unmute Eric and get him speaking in just a moment. Okay, while we get this figured out, I'm going to ask, we're going to switch, and my colleague, Doug Stanger, is going to talk to you a little bit about the impact of the COVID-19 response on bankruptcy law. Doug, if you will.
Okay, can you hear me?
Yes.
Okay, that's a good thing. Okay, so if we can move up the slides. Another one, another couple. Perfect. Okay, thank you. My name is Doug Stanger. I'm a partner here in Flaster Greenberg and a member of our bankruptcy and restructuring practice, along with our corporate and tax practice groups. I've spent my career advising businesses on a whole array of issues that have confronted them. The current work stoppage due to the pandemic is certainly a unique occurrence, but dramatic effects on companies by outside forces is not. And we need to proceed based on those experiences and strategies to move forward with this crisis. Thanks, Adam, for your discussion about how to handle issues concerning your employees, your workforce, which were thrust upon us just a few weeks ago, and which all of us are dealing with, whether big or small. And the discussion you're going to hear about Eric really focusing in on the tax legislation and what it means to you and what benefits and what ability you are to recoup some of these losses is so critical. As to the extent of this crisis and our new reality sets in, what I expect we have all been doing and must continue to do is a very methodic assessment and confrontation of the economic impacts on our companies and the reassessing and confronting realities as they continue to develop. This has been coined already as a pandemic resiliency plan. How to plan for a resilience that will have us thrive on the other side of this crisis. I recognize that with maxed out participation on this call, each business is unique. There are businesses that produce goods. There are businesses that are service industries. There are companies that lend money and borrow money. But we are all confronting the basic challenges. Before I start, I just want to remind those who are directors or officers of companies that the steps I'm going to talk about are not only wise, but really what needs to be done to fulfill statutory and legal fiduciary duties as directors and officers. The duty to make informed decisions in good faith and in the best interest of the company. And for that matter, when a company gets into a zone of insolvency, how to maximize the assets for everyone. So now you have somewhat downsized or at least reduced your labor costs with the advice of Adam, and understand some of the tax benefits which are enacted, which Eric's going to explain. It's time for you to really focus on outlining the threats that still exist and will continue as we work our way through the crisis, and also, of course, the potential opportunities that will arise. Again, pandemic resiliency planning. The first thing to do is put together your team. You know who those people are. Key management individuals who know your labor force, understand your budgets, your cash flow, supply issues, demand issues. You may be a smaller company who then I would suggest you should talk to some people and try to bring in someone to assist you, perhaps an accountant or even a trusted advisor. So how do you form this pandemic resiliency plan once you have the critical players involved? This is really going to require an understanding what the threats are to your company and where and when opportunities arise. Primary right now in everyone's mind, and actually we're a slide ahead. You can go back to the slide before for another moment. Primary right now in everyone's mind is liquidity and cash flow. This has been and will continue to be primary on the mind. There's been loss of increase and increased expenses. How do we project things will go over at least the next 90 days? Okay, now we can have a slide change. What external factors are at bay in continuing your business? How are your suppliers doing? How is your customer base doing? What can be expected from them? We need to think beyond the crisis. Experts are all saying 90 to 120 days. It could be longer or shorter, but that is where you need to start. What about your workforce? Will everyone laid off come back? Will your existing labor force be sufficient, more or less? And it's a different, situation for everyone. Will you adapt to more remote workers? Does that make sense? A lot of us are seeing that perhaps it does make sense and we can do some cost-cutting measures into the future. Okay, next slide. Part of that realistic 90-day plan will be to take into consideration the triage process you've been undergoing. How has your labor force been reduced? What contracts can you perhaps cancel, or do you want to cancel, or have been canceled? Taking a look at those contracts. How about facility agreements? Where you have your operations? Have you been able to reduce your rent? All a part of a plan getting ahead. Okay, moving on. As part of your resiliency plan, you will have to determine what additional operating capital you'll need. Aside from your own personal funds or existing lending relationships, it's critical that you understand the impact and opportunity presented from the unprecedented inflow of funds from this government bailout, which Adam talked about and which is getting more clearer by the moment and should again be passed tomorrow. Loans versus grants, what the realities are on these tax credits. I can tell you we're compiling a list right now and we'll be making it available to our clients and to others of what all these programs are. The federal government, certainly the Small Business Association has come out with loans that they're willing to give. They already have an application form on their website. In Pennsylvania, Philadelphia, Centric, there are a number of loans and grants just for those that are in Philadelphia. There's the Philadelphia COVID-19 Small Business Relief Fund, which has grants, some smaller ones, even $5,000 for business with less than $500,000 in annual revenue, but it goes up to $100,000 per business with those between $3 million and $5 million. The Philadelphia Industrial Development Corporation, the PIDC, has various loans and abilities to take tax advantages in order to get some relief for your entity. The economic development of the DCED, the Pennsylvania Department of Community Economic Development, has a working capital access program. Then there's the Pennsylvania Industrial Development Authority, PETA, who has put together $61 million available for business assistance. Funds can be used for working capital loans up to $100,000. The interest rates of 3%, but the PETA board can actually reduce that as low as 0%. And there are others. Here in New Jersey, there's the NJEDA, the New Jersey Economic Development Authority, that has passed legislation to make grants available for businesses to provide working capital and meet payroll requirements. So there's so many different opportunities that are out there, and it's a matter of understanding first what your cash flow need is going to be. Then can you afford, and does it make sense to get loans? Can you get grants? And all of this is a piece of that puzzle in putting together and taking care of your pandemic resiliency planning. Move on to the next slide. And of course, we must also be cognizant that any analysis may lead us to a conclusion, no matter how much we try to run and hide from it, that the company will not be able to survive this loss. This is especially true to companies that were struggling at some level before. Taking on additional debt may not be satisfactory. Even a grant which really is tied to keeping employees working may not help, because we can't even afford to keep those employees on the payroll, either ever or until the funds arrive. Our initial goal is always to see if the company can survive without a bankruptcy. Can deals that make sense be made with lenders, suppliers, landlords, any debt holder? If not, an analysis needs to be done if bankruptcy can assist. If creditors are not being reasonable or reasonable enough, it is possible to compel them to take a fraction of what they are owed in a Chapter 11 reorganization. I want to say that again, it is possible in Chapter 11, and that's the goal of the Chapter 11, to reduce that debt to a fraction of it in certain circumstances so that a company can come out strong. And even right now, to utilize the brand new small business bankruptcy, Subchapter 5 is a new bankruptcy section which became effective just February 18th, 2020 for businesses with total debt that do not exceed $2.725 million, $2,725,000. And that is meant to be a streamlined, lower cost Chapter 11, as Chapter 11s can be exceptionally costly. And if those alternatives don't make sense, it may be best to close the business, file a Chapter 7, form a new entity, and start over. Bankruptcies have always been a driver for the economy. It's an opportunity to hit the restart button. Virtually everyone that comes in doesn't want to file. But I can tell you many stories of people coming to me a year or years after their business bankruptcy, thanking me for helping them with proper professionals realize they needed to tank one company and start another. Everyone comes in with great hope, as they say, hope runs eternal. But the longer it takes to get to the realization that it won't work, the more stress and aggravation. It can be tremendous. So the sooner one reaches that result, if it is appropriate, the better for all concerned. Next slide. Lastly, I do want to mention that this crisis is affecting creditor rights in a major way. And I expect a number of our participants are landlords or lenders. And most of us businesses are at some level. We become lenders every time we give credit to our customers or clients, even just giving them 30 days to pay. Based on whatever agreement, contracts you have, there are going to be many rights and decisions that will have to be made, whether to litigate or work out these obligations when there are defaults, whether it's with tenants, whether it's with borrowers, whether it's with customers. Creditors need to adequately assess the likelihood that even workouts are feasible. What is the best way to handle? Does it make sense to terminate and move on or not? In addition, in all likelihood, those creditors will be debtors to others, like landlords, to banks who hold mortgages. Their own creditors will need to be part of this national solution. In conclusion, in order to give people the most opportunity for questions, the main takeaway is putting together your team, preparing a written analysis of your current situation, your company's pandemic resiliency plan. Expect it for 3 months. Expected businesses will come out of this. As we come out of this, we're going to see opportunities. And if you find your situation has a poor likelihood of success, sooner than later, put your team of accountants and lawyers together to see what other options are available and make sense. As we all get through this together, we're there for you and will continue to provide advice on how to proceed. I'm now going to pass this webinar back to Eric, my associate, who will talk about in a little bit more detail some of these tax aspects and things that will put money in your pockets as part of your plan. Lastly, I just want to say that I recognize people don't necessarily feel comfortable asking questions about their company's financial distress. Certainly, we welcome those questions now or in the abstract. However, feel free to call me after the webinar, and thank you for attending.
Thanks, Doug. Can you hear me now?
We can.
Oh, great. Sorry about that, everyone. Had technical difficulties here. Hi again. My name is Eric, and I'm an attorney with the Taxation, Employee Benefits, and Corporate Groups here at Flaster. As Doug mentioned, over the next few minutes, I will be reviewing the available refundable tax credits that are provided under the FFCRA. Here, you'll see just a summary of the tax credits that are available for everyone. They effectively equal the same amount of required paid leave you are required to pay under the FFCRA. And as you can see listed here are the amounts that you're required to pay under the Act as described by Adam earlier in his portion. So the amount of tax credits provided is the same for employers and certain self-employed individuals. However, the FFCRA under the FFCRA for self-employed individuals, you can use that tax credit to apply it to your federal income tax withholdings, whereas the employers may only apply the tax credit to their portion of the payroll taxes that they are liable for. Now, you should note these credits are increased for amounts an employer or certain self-employed individual incurs for qualified health expenses and Medicare taxes paid. Qualified health plan expenses are amounts paid by the employer to maintain a group health plan, but you only get a credit to the extent such amounts are excluded from the employee's income that are allocable to the qualified sick leave being paid. That's the extent that the Act gave guidance or definition on what qualified health plan expenses means. And the Treasury is expected to release additional guidance to tell us how to make this allocation. But essentially, presumably, you will get a credit for your portion of your payment to for healthcare coverage for your employee, to the extent it's it's excluded from income and they're not that amount is not already taxable. Moving on. So here's just a general slide to give you an idea of where these tax credits can be applied. As I mentioned, for employers, the refundable tax credits they receive can be applied against employers' portion of FICA taxes. The employee's portion is not impacted. For those certain self-employed individuals, the tax credit can be applied against federal income tax withholdings. So what will happen is, you'll receive a credit equal to an amount amount of the paid leave that you pay under this Act, and you will be able to apply it to the employer will be able to apply it to their portion of, essentially the FICA taxes. So the 1.45% portion and the 6.2% portion of OASDI. Now, moving on. Now, how does this actually work? So as most of you all probably know, as we just mentioned, employers are required to file a quarterly payroll tax return and deposit their payroll tax withholding. And this payroll tax withholding, consists of both the employer and employee portion of Social Security taxes. Now, under the Act, the employer will be able to apply their tax credit, their refundable tax credit, dollar for dollar against the amount of payroll taxes they would otherwise owe for their portion. So effectively, this allows the employer to keep cash that otherwise would have been paid as their portion of the payroll tax. Now, if the employer's FICA liability happens to be less than the credit that is available to them, they will receive a refund from the government for that amount. In other words, your excess credits will be treated as if you overpaid the government and you will receive a cash refund. Now, I should also mention that this tax credit available for paid leave under the Act cannot be used, cannot be taken, the wages paid under the Act cannot be taken into account for payments for purposes of the 45S credit. Some of you may recall under the Tax Cuts and Jobs Act, there was a new tax credit allowed for employers who opted to pay employees while they're out on FMLA. And you know, the rules do state that you basically can't double dip in this instance. Moving on. So the next 3 slides are just examples to try to illustrate how this tax credit works and how it relates to the qualified paid leave under the Act. Next slide. I think the second example is the best one to just quickly go over. So you guys can go on this, go review this on your own, but essentially, so this is the middle of a road. I did 3 scenarios. The first example involved using an individual with a $200,000 annual pay. This example uses an individual with $100,000 of pay. So here, if you divide their weekly pay, you get $1,923, and that's based on 52 weeks per year. They divide that by 5 days per week, so we get an average daily pay of $385. Now, under the provisions that Adam spoke about, the non-related leave pay, you will still get 100% of that. So that's not capped, so you'll get $385 because the cap on that portion, similar to the tax credit cap, is also $511. So your employee will receive $385. Now, over a 2-week period, the total is $3,846. Now, for tax credit purposes, effectively, it's the same outcome. They'll get 100% of that. An employer will receive as a tax credit. And so you see, if you keep going down, it's unlimited. But if you look at the second leave scenario, it's a little bit different. So the employee characteristics are the same, but if you look at the non-tax related leave pay, so there, in Adam's, under the required leave pay, your employers are required to pay 2/3 of the employee's regular salary. So in this situation, 66% of daily pay of $385 would be $256. However, as Adam also mentioned, this amount is capped at $200. So they would only be receiving $200 times 10 days equals $2,000. Now that amount, $2,000, the employer gets 100% of that as a tax credit. So they will get a refundable tax credit equal to $2,000. So that's just an example of where the portion under Adams, technically, I guess it is limited to some respect based on the calculation, but under the tax credit, that you still get the full amount out of your pocket that you're paying your employee. And that's all for me. I think, do we have time for questions?
We do, and we've received some via chat. We probably received more questions that we're going to have an opportunity to get to before the session ends, but I think we'll at least take a stab at getting to the ones that came in first. So if your question isn't answered, certainly feel free to reach out to one of us and we can try to address it individually at another time, and our contact information's up there. But let me get started, and I will start with one of the employment related questions. In particular, I think it's important. The first question is, does the new FFCRA apply to companies with fewer than 50 employees? It's an important question because that is the cutoff typically for Family Medical Leave Act. So I'm glad somebody asked it. And the answer is yes. It applies up to 500 employees, even if you just have one employee. There is, however, and that's why I'm happy somebody asked, a potential for an exception. It does allow the Secretary of Labor, the Secretary of the United States Department of Labor, to create a particular set of regulations that would allow smaller companies, companies with fewer than 50 employees, to opt out under certain circumstances. They would basically need to be able to show that complying and offering this leave would compromise the viability of the business as an ongoing concern. How an employer shows that has yet to be determined, because we don't have those regulations yet since the law just came out last week. But there is some potential opportunity there. I think you would need to be able to show that providing this leave really does jeopardize the viability of the business, and I think that showing is a fairly high standard given the tax credits that Eric just talked to us about. I'm going to move on from employment for a moment and direct one of the next questions to Doug. Doug, you're not on mute, right? You can hear me?
1 second. Now I can.
Oh, good. Doug, all right, good. We can hear you. Doug, somebody asks, what's the difference between the Chapter 11 and the Chapter 5 you mentioned in your presentation?
Okay, obviously that can be a whole hour's worth, and perhaps will be one of these future webinars. We've done this in the past, and actually even before this pandemic, we were considering doing something on this subchapter 5 because it is brand new. Basically, Chapter 11's cost a tremendous amount of money. The process is made for the billion-dollar company and the million-dollar company. So has not been a good process. There was a previous small business section of the code that did provide some relief, but there were issues with it. That one actually still exists, but Congress put into effect this subchapter 5 to really reduce the cost of basically a reorganization, where you have the ability to bang down creditors and come out of it and retain the company. There is a trustee that's appointed, which is unique in every case, because in generally Chapter 11s, there is not a trustee, but the goal of the trustee is to quickly analyze the company and assist with regard to getting their plan of reorganization together. The goal is really within a few months to get in and to get out. I'm actually one of the people. There are 10 of us in New Jersey that were chosen to serve as panel trustees. We can still certainly represent businesses, but we will also be assigned cases in our geographic areas. So we're well versed in the subchapter 5. But the bottom line is that it does provide for those under that 3,750,000 gross annual receipts, to provide them a great alternative, a less expensive alternative to reorganize their company.
Excellent, Doug. I think that was very helpful. So I learned something, so I appreciate it. Next question, again, I'm going to go back because it is an employment-related question, and that is, can a furloughed employee receive unemployment compensation? Again, that gets to sort of how you define furlough versus laid off. The fact that you term somebody furloughed does not make them ineligible if they would otherwise be eligible for unemployment. It's the fact that they didn't have any earnings in an eligible week. So if you do treat somebody or use the word furlough, as long as you're clear that you're not paying them wages and that they aren't working during that period of time, and they're otherwise eligible, that would not interfere with somebody's eligibility for unemployment. And that brings an important point up that I also want to mention, which is that if you do reduce somebody's hours, they may also be eligible for partial unemployment. Now, partial unemployment uses a fairly complex calculation to determine what the benefit was, and then it can be offset by the earnings. So depending on the person and their earnings may be high enough that they offset the benefit, and therefore they are not eligible. But certainly there's a potential to be eligible, and employees should be applying. I read today that unemployment applications broke the all-time record, which I'm sure is not going to surprise anybody on the phone. So with that question answered, the next question I got also was for you, Doug, so I'll put that on. And that is, when should a business come and talk to you? And when they do, what is it that you need to see in order to advise the business?
Okay, it's a good question. Certainly when this sort of light bulb goes off that it doesn't look like this company is going to be able to survive this, the sooner the better, because there are all sorts of issues, potential personal guarantees that may have to be dealt with. There may be strategies as to how to navigate through paying creditors at the moment and not paying creditors, and how to try to do this in the most efficient and proper fashion. So always the sooner. The companies that come to me when it's too late to do any bankruptcy planning, as we call it, really can cause trouble, all around. So the sooner the better. And I should say that, if a company was struggling before this pandemic and perhaps even in default on some of its obligations, to think that they're going to be able to borrow or grant their way out of whatever problem they had before is probably not realistic. The expectations are in these grants and these programs that they're still going to be looking at the company's, economic viability at some level. And in addition, borrowing more money when a company is already, having problems is probably, again, not the way to resolve them. And it's probably time to be considering other options. With regard to what I need at that point, the best case scenario is I have someone who comes in with their, pandemic planning that you can see goes awry. That's really, it gives me some financial information so I understand the business quickly, and we can start working through whether we have to file or don't have to file, whether there's additional workouts we can do, whatever. So it's really your basic financial information, who you owe money to, what you own, and what your cash flow is and what it's been projecting. So it's basic information.
I think we have time. It's about 3:01, so we really don't, but we'll answer one last question, and that relates to at least the emergency paid sick leave. And the question is if the school is not closed or the daycare isn't closed, but somebody pulls a child out because they're frightened, or they entitled to leave. So the statute here really says that leave's available if the school or place of care is closed, or the child care provider is unavailable due to COVID-19 precautions. So it really does refer to a closed school or an unavailable child care provider due to COVID-19 precautions, meaning that if an employee were to say simply, I don't want to send my child to an open school because I am frightened, that does not come squarely within the leave law, at least as it's currently been written and interpreted. With that, I want to thank everybody for logging on and for joining us today. Again, a couple of closing points. Please let us know if you do need an attendance certificate. You can send that email to marketing@flastergreenberg.com. Also, whether you need an attendance certificate or not, please be sure you did provide your name and email in the chat. Additionally, if there are topics that interest you, again, I'm going to encourage you to please let us know. You can do that by way of chat so that our future webinars can cover topics that are of interest to attendees. I do again want to thank you all for attending. I certainly wish it were under better circumstances, but we are all in this together, and I wish everybody to stay healthy and certainly to stay tuned for additional updates and information. Thank you so much.